get
I was really
on the bandwagon of public.
And I brought this in case.
I hear that loud and clear. That's.
For me too. I mean, I have like a 20-minute walk.
Wait, did you just do this once the metro came to Santa Monica?
I couldn't have tried to do it. I had nothing to do before the
Okay.
There was no way to get here but drive.
Yeah.
What?
It's a nightmare on the 10 though. Like,
There's no way of getting because
You don't have access.
so Silver. I mean, like you said, yeah.
we have no. There's nothing near us that.
Right.
I'm saying.
No, another one.
Website.
Yeah, not convenient. Yeah, totally not
Oh,
convenient.
I'm sorry. We just said surface streets. Okay.
We are broadcasting though. Correct. Okay.
Subway station.
Oh my God, seriously?
Whoa. That's on.
But how long does that take you?
It takes me the same.
Really?
In the morning it takes a while.
I'll say something. I'll say,
Yeah.
stand in, we'll do it. We're just gonna do it.
Yeah. I've seen the because I do the reverse, right? Because I drive downtown, they come here. I see what the 10 looks like. I'm just like, oh my God, nightmare. Yeah.
On a typical day, driving all of here to my house takes me an hour, 8:25, and 8:55, including the 20-minute walk from the subway station to my house. It's an hour. Saying the library's going to be closed. It's so much.
Yeah.
That's right,
Yeah.
you gotta go fast because
Oh my God, now I'm feeling like guilty that I don't do that. Yeah. Right.
I don't get my stuff before, but I could.
Right, because you just don't fill it out.
Yeah, I just don't.
That's exactly how I am. Anytime they're like, "Oh, get your mileage reimbursed." I'm like, whatever. Like, I'm too lazy. Yeah.
But I do save a ton of money on
Gas.
my car gas.
Yeah.
Because my car gets probably 45, 50 miles a gallon anyway, so it does pretty well. But I'm now putting gas in my car like once a month.
Oh my God.
And
Next.
it only costs like
Wow.
$25 to fill it. So.
Well, Haka, I'm gonna pick your brain later about where all the foodie destinations in Silver Lake are. Okay. Or Steven, you can tell me too. Maybe you're a foodie. He just said he was a foodie. That's why I asked.
I didn't say that you accused
No, I didn't accuse. I don't think that's a bad thing. I would definitely say my husband and I are.
I wouldn't characterize myself with that word, but I do like to eat.
Yeah, no, there's good restaurants over there.
all right. You guys ready?
Yeah.
Everybody ready? Yep. All right. I'm gonna use the thing today because why not? I only have,
gavel.
I'm gonna use the gavel.
Wait, I just want to make sure this is like covering my legs, right? Yeah, that's good. Because I just have.
Okay, wait, where do I start? Closed session. Okay. The meeting of the Rent Control Board is
Can you
hereby
hear it?
called back to order after its closed session.
Okay.
Kind of unusual tonight. We don't have a flag, but I'd like for us to stand and all envision a flag in your own minds. And we'll take it from there.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, now I would like I don't hear myself, so can you hear me out there?
I don't think your thing is on.
Yeah.
I can hear myself.
Now can you hear me? There we go. Okay. So if anyone would like to address the board, either on a specific item this evening or at public comment, I just want to remind you that our secretary is over here to my left. Please remember to bring a chit or fill out a speaker slip, which we call a chit, and then you can be heard. Report of closed session. Okay, we'll do. Would the general counsel or administrator please report on closed session?
Yes, the board convened into closed session at 6 o'clock and adjourned from closed session at 6:38. There were two items under consideration, both litigation matters. One was pending litigation, the other was prospective litigation. With respect to the pending litigation, the board took no reportable action. With respect to the prospective litigation, the board authorized general counsel to enter into a settlement agreement of that prospective litigation. Thank you.
Thank you very much. Okay, approval of the minutes. May I have a motion to approve the minutes of the board's last meeting?
So moved.
Okay, there's been a first, a second?
Second.
First and a second. Any discussion? No? Okay, then we'll take a voice vote. Approval of the minutes for last month's meeting. All in favor?
Aye.
Any opposed? Any abstentions? Okay, the ayes have it. The minutes are approved as written. Special agenda items.
Yes, good evening. Can you hear me? Is it on? Okay, good. So I just wanted to tell the board and the public about two events that are coming up next week. On Tuesday, December 12th, we'll be having the 4th Annual Landlord-Tenant Forum that we offer with the, in combination with the City Attorney's Consumer Protection Division and the Rent Control Agency. That will be here in this auditorium the morning, next Tuesday from 9 to noon. Registration starts at 9. The program will start at 9:30. We'll be talking about hot topics in landlord-tenant law, including tenant protections during construction, the seismic safety retrofitting program, the new rent control information sheet that must be provided to new tenants, and current issues related to tenant privacy. So I hope you can join us. If you're interested in signing up, please contact through either smgov.net you can register, or calling the City Attorney's Office at 310-458-8691. And it's usually very well attended, so if you're interested, please sign up as soon as you can. And then the other thing is a holiday party at City Hall. They call it the City Holiday Party. It's next Thursday afternoon, December 14th from 3 to 5. Every department has some food offering, and it's just an opportunity to get to see everybody in City Hall. So if you're interested, please join us, both the board members and the public. That's all I have this evening.
Thank you very much. Commissioner Trost has had a question.
Yeah, if members of the public wanted to get more information about that, is it online?
The City Holiday Party?
No, the Consumer
forum.
Protection
Yes,
Forum.
the Consumer Protection Forum, both on our website, smgov.net/rent control, and the city attorney's website. I'm not sure what their / probably city attorney, so yes.
Can people sign up to be on an email blast notification so that they can get advance notice of those?
Yes, I think if you've attended in the past, you will, and you've signed up with them, given them your email, you will receive that notification. So yes, you can do that.
I would just say that I think we should let people, or have people sign up, not just if they've attended in the past, but if they go to our website and want to receive notification of these, can they
Yes.
get an email?
Yes, we ask people to give us their email, sign up, and we send them
Okay, great.
notifications about this type of event.
Everyone sign up.
Very good. Thank you very much. Okay, one quick reminder I forgot to mention earlier. We have parking validation for any of you who need it. You can see our secretary, and he can have that for you at the end of the meeting tonight. I'm also, now we're moving into public comment, and I just want to let the public know that this is the time set aside for members of the public to address the board on matters that are not on the agenda, but that are still within the board's jurisdiction. So please note that this is your chance to speak with us tonight. We cannot take any official action, but we would love to hear from you. So moving on to public comment, I have a request to speak from Nicholas Gross, and he has requested 3 minutes. And I believe, it looks like he knows already, the podium is up here on the stage with us. Whenever you're ready,
Hello,
Mr.
hello,
Gross.
okay. I'd like to go kind of quickly because Mr. Duran, 3 minutes is 3 minutes. Just to conclude on what we discussed last month, I just wanted to some more light on a couple other points.
Hang on one second. I think if you push the button in the underneath so that it's up.
So it's up.
Hello, hello, it's up.
There you go. Bingo.
Okay. Exit Editor is a $10.99 desktop app for Mac that exists for the sole purpose of editing the metadata on photo files. This app is primarily for professional photographers who might use it to remove camera or software information from a photo before sending it to a customer. You might also use use it to edit or to restore lost information like location, author name, and of course XIF data with an iPhone app. Here you go. This option is one step easier. The 99-cent iPhone app EXIF-FI lets you view and edit the metadata for any photo on your phone. It's much cheaper because it's pretty basic, but it has everything a photo evidence would need. You can change the geotag, the date, and the time, and you can do this to multiple photos at once. Anyone could, if they wanted, download this app and spend a mere 99 cents and 30 seconds of their lives creating a revisionist version of history. Now, this is not from me. This is from Vimeo, trusted by millions worldwide. The Rent Control Office has this information along with hundreds and hundreds and hundreds of photos properly done with the timestamp in the photo taken of another device as well as the subject of the photo. Not only the photo with another iPhone, but with an iPad, all with world clocks, and of course a MacBook Pro. Why is it important? It's because metadata is never admissible evidence in any type of hearing. So when we have a hearing about whether someone is living or residing in good faith, that's what it's about. It's not about timestamps in someone's phone. And Judge Naliboff, I think I said her name right, knew this. That's why she didn't give any weight to evidence. She's not going to accuse anyone of being a criminal or being fraudulent. She's just going to say, hey, she knew all this. So that's why she didn't give any weight during the hearing. That's why the hearing went on the people who were telling the truth side. And that's what these issues come down to. One side is telling the truth. One side is not telling the truth. And when the judge decides one side's telling the truth, and then we come here and people are looking at things that shouldn't be looked at, it's kind of frustrating to the people telling the truth, because even though you're not saying the other side's not telling the truth, it's almost insinuated. But anyways, there is a process to correct things, and we're most of the way through. I want to thank Dan and his staff, and we'll see what happens a couple weeks down the road, because you know the truth and honesty is what should matter in front of the judges, in front of the board, and not to have a quick speaking lawyer come in here and direct people off to look at metadata when.
Thank you, Mr. Gross. Your
that's
time.
our 3 minutes?
Yes, your 3 minutes.
All right, well, thank you very much, and thank you very much for everybody listening, and happy holidays coming up.
Thank you. Before you go, Commissioner Phyllis, I believe had a question.
So, Mr. Gross, I know that we've seen you several times at these meetings, and we're obviously, we are concerned about this. I mean, we're all trying to do the best that we can. I believe that there is a process that you can initiate to challenge the owner occupancy exemption, and then there's a process through which staff will investigate the challenge. And, you know, I would like to say on the record that Mr. Gross does present some concerning evidence about the way I would expect and hope that staff, if there is, you know, if we find that this challenge is credible, will examine that at the hearing. I mean, the big problem that we had, and the reason why this came up at the last hearing, is that the photographs weren't examined by the hearing officer at the time of the hearing, and we did it on the dais as we're permitted to do. We're sitting as a board of, we're allowed to take evidence. That I'm telling you, like, we are permitted to do that. That's allowed.
No, I understand. The hearing officer did look at the phone. As far as her photo evidence, all she did was hand in emails with little attachments. They were never.
Right, she didn't examine the phone.
Well, no, she did. She looked at the phone that was handed over. She asked why they were. She asked about all the different bursts and everything else. It's all in the transcripts. And Ms. Chen said she was home at 5:30 every night and had, you know, false charts made. But now they have photographic evidence that she's not home at 6, 7, 8, 9, 10 o'clock, leaving up till 10:30 at night. They'll get to it.
I mean,
They'll get to the bottom of it all.
without going any further into
Right.
it, I trust that there's a process. I trust that
Right.
the process is underway. And I trust that as part of this process, careful attention will be made or drawn to the credibility of those pictures.
Right.
And I would ask that staff pay particular attention, given that Mr. Gross has alerted us to this issue.
Well, you know, it's just hard
Thank
when you
you.
win the
Thank you, Mr.
hearing,
Gross.
and then there's a 3-2 vote the other way, but the
Mr.
judge
Gross.
rules in our favor, and then there's a 3-2 vote based on metadata when the whole thing.
Thank you, Mr. Gross. Thank
should
you.
have never come.
Your time is up.
Thank you.
Thank you, Mr. Gross.
Thank you, everyone.
I have another speaker, Candace, I believe it's Vintage. You've requested 3 minutes. Well, you can take up to 3 minutes.
Okay, I'm surprised I'm able to speak. Hi, my name is Candace, and thank you for being here. I live,
Push the button. I think he pushed it down. Try it again.
okay, is that better? I can't stand on my toes. I can speak loudly.
There you
Okay,
go.
I live in Santa Monica. I love it. I went to high school here. I got a job here. I moved here because of my job. I moved into a dwelling that was just deemed like toxic because of mold. And I've been complaining about it for months, if not years, and been very sick over it. Anyways, they've just relocated me to a different unit. Sorry, I didn't know I'd get emotional.
It's okay.
I've always paid my rent. It's a nicer unit because it's on a higher floor. But I would like to get the reports from the toxicol, or whatever it's called, the air quality tests. My dog died. My mom developed a really bad sickness since she started visiting me there. I'm not saying that's why, but I have a lot of medical issues that I didn't know were related at all. I didn't connect them. So I just want to try to find out how I can make myself and people who come to visit me safe, because I don't have anywhere else to go to. And I am feeling a little better actually in the new apartment. But I've heard some horror stories, and I just want to know what I can do to protect myself, to make sure that I'm as healthy as that I can be living there, and if my family wants to visit me or anyone else, that they're healthy as well. So I don't know.
Okay, well, thank you for those comments. I would recommend that you speak to our staff, either.
I've been to your office many times, and within like 48 hours after getting me out of the unit I was in, I wasn't home. I was with my family. It was my birthday on the day they did it, so my family came in to take me to dinner, and they said they had a moving company and I was going to be charged if I didn't arrive there with the movers. I never made arrangements to move. Now, I obviously prefer this apartment because it has a better view, and it's the same price they told me and all the same conditions. So that's fine, but I just would like to get some kind of report or something of what I was living in, because it really connects a lot of dots. And so who do I go to for that? Because they won't give it to me. And
Well-
I've been told by the people who work there and by the outside private companies how toxic it was, like the worst.
Okay, so we can't give you counsel
Okay.
here at the dais, but I would strongly suggest that you could talk to one of us after this meeting, or you could talk to our staff, and maybe they can point you in a direction or something that they can tell you. Commissioner Terosas.
Yeah, can
has something to
staff
say.
talk with her? Can someone from staff talk with her right now?
Yeah, Mr. Costello there in the
Yeah,
front.
thank you.
Yes.
Or-
Mr. Costello there can talk with you some.
The other thing I would say, again, we can't provide you with legal advice, but
I've
no.
spoken to lawyers. I just didn't want to go that route. I'm not into that. I love living there, and I love Santa Monica. I don't want to have,
Right.
like, I want to be happy when I walk into my building, and like I always have been, and say hi to everybody. And I don't want to feel like I'm doing anything inappropriate or wrong or getting anyone in trouble. I just trying to be an adult, basically.
Right, and I think we want everyone to be happy and feel safe here. I would definitely recommend talking with staff, and they can let you know if there are any other appropriate government agencies that could or should be involved from a health perspective.
You would think they'd have to give that information.
And if we need to follow up, definitely we can do that.
Thank you very much.
Thanks for coming.
Oh, Commissioner Phillips.
And to the extent, I mean, this is not advice in any way, but to the extent that you have, you believe that any of this information is a public record, California has a Public Records Act.
That's what I didn't know,
Mhm.
and for some reason I thought it would be, and you're saying it.
California has, so I would reach out to the city clerk. The city clerk is the person who's in charge of all public records.
Okay.
And the city clerk can tell you if there's a public record that may be responsive to what you're thinking about.
I had a code enforcement officer come twice and deem it habitable, but like within a day or two after getting me out, it was, the double coated plastic and deemed inhabitable. So it really doesn't make sense
Why don't you speak?
I would definitely
speak
talk to the city
staff.
clerk, who should be able to get anything from code compliance that's in the public record.
Thank you very much.
Okay.
I appreciate all your time. Very much.
Thank you.
Okay, we are now moving to jurisdictional items number 10. This is an exemption, owner occupancy, case number 1766, 701 Marine Street. Applicants are S. Hatfield and L. Hatfield. May we have a staff report, please?
Commissioners, the Hatfield bought this 2-unit property back in April of 2016 and state that they moved into it the following month. They've applied for its exemption and as an owner-occupied property with 3 or fewer units. They are the sole owners, so they've satisfied the percentage ownership interest requirement, and the property also meets the unit limit for an exemption. The only remaining question is whether they have lived in the property as their principal place of residence since at least May 25th of 2017, which is 120 days prior to the filing of the application. They submitted utility records, financial statements, and government records that show that they've used the property as their mailing address during this period. They don't own any other residential property in LA County. DMV, voter registrar, and the city's water, sewer, and trash records all show the property as their address. The tenant on the property confirmed that they live there, and given that record, based on the preponderance of the evidence in that record, which shows that they have met the requirements for the exemption, staff recommends that the board grant this application and adopt the attached findings of fact and conclusions of law.
Thank you very much. There are no chits to speak.
Move to adopt findings of facts and conclusions of law in the staff report.
I have a comment.
Okay, there's a motion. I know that there was some commissioners who had to speak, wanted to speak on this item. So Commissioner Foster.
Oh, shoot, I didn't, sorry.
That's okay. Thank you. So Commissioner Phyllis took the words out of my mouth. The facts seem very straightforward. The applicant has met the burden of proof in the staff's opinion and in mine. So I would second the motion in this case.
I have a question.
Okay, there's a question from Commissioner Trezos.
Okay, do we know why the exemption lapsed in 2014? I understand that they only moved in on May 2016, but do we know why it originally lapsed and there was a 2-year gap?
The property was sold, that's why the exemption lapsed.
Between 2014 and 2016?
I'm sorry, I'm not sure.
Sorry,
that I
no, I'm
understand.
just,
The property, an exemption was granted for owner occupancy in the past, and when the facts that give rise to an owner occupancy exemption cease to be true, the exemption elapses by operation of law.
Okay.
The previous people moved off the property,
Tw-
and the exemption
2014.
lapsed.
Okay.
And then it was not owner occupied for a period of years, and now it is
Okay.
owner occupied.
Do we have any indication as to why they waited for a year before applying for the owner occup? Oh,
We
they
do
are?
not.
Are they here?
No one has requested to speak, so.
Because if they purchased it in May 2016 and then they only have started to establish this as their principal place of residence, in May 2017, I was just curious. But again, none of those pieces of information changed my mind. I mean, I would say that it's pretty cut and dry here.
Okay, having heard that, has been a first by Commissioner Phyllis and a second by Commissioner Foster. Any further discussion? All right, having seen none, we will take a roll call vote.
Yes.
Yes?
Yes.
Yes. Thank you very much. Moving on to appeals, 10B. First one is case D 4957, 1321 Oak Street, Unit D. Appellants G. DeBaca and G. Seaman, and the trustee for Craig C. Carr Living Trust. May we have a staff report, please?
Commissioners, tenant Gina DeBaca filed a rent decrease petition in this case, and because of the unit's dilapidated state, the hearing officer awarded her a substantial decrease in the amount of $790. She's appealed that decision because she disagrees with the hearing officer's finding as to the initial rent for her unit, which is the basis of her maximum allowable rent. The hearing officer found that initial rent to be $1,750. She claims that it's half that at $875. The now deceased owner of the property, Craig Carr, registered her tenancy with an initial rent of $1,750. Because Ms. DeBaca disputes that amount, she bears the burden of proving that it was erroneous. She testified that she was supposed to move into the unit in June 2016, but that was delayed until July because it was not in livable condition. Her testimony is consistent with Mr. Carr's registration form, which states that her tenancy began on July 7th, 2016. Ms. DeBaca's first rent check, dated June 4th, 2016, was for $1,750, consistent with Mr. Carr's registration form of her initial rent amount. But at the hearing, Ms. DeBaca testified that this was actually for 2 months, for June and for her last month's rent. The check includes no notation that supports her claim that corroborates her explanation. In fact, her claim is inconsistent with her own testimony that she moved into the unit in July and that the first month's rent, therefore, would be for July. In August, Ms. DeBaca paid another check. Again, the amount of that check was for $1,750, consistent with the amount registered by Mr. Carr. Subsequent checks that she submitted into the record were for varying much smaller amounts and proved nothing about her monthly rent. The only check that she ever paid for her claimed initial rent of $875 was the last check that she submitted, which was in April of 2017. Ms. DeBaca also claimed at the hearing that when Mr. Carr tried to evict her for non-payment of rent, the judge found that she had paid all the rent that was due. If that is the case, that would mean that the judge necessarily determined what her monthly rent was. She was asked to produce documents from the UD, and the record was held open for her to do so, but she never did. Therefore, she failed to provide evidence that refuted Mr. Carr's registration of her initial rent, as is her burden. The record reasonably supports the hearing officer's conclusion as to her initial rent and more. Ms. DeBaca also claims on appeal that the signature on Mr. Carr's registration form for her tenancy was forged by Mr. Carr's son. She provides no evidence to substantiate this claim. In fact, a comparison of Mr. Carr's signature on the registration form shows it to be stylistically similar to earlier forms he submitted to the Rent Board back in 1979 and also 1992, except that it appears to be written with shaky hands, which are consistent with his advanced age and ill health. But it is not staff's burden to disprove Ms. DeBaca's forgery claim. It is hers to prove it, and she provided no evidence that does so. Ms. Saman, the trustee of Mr. Carr's trust, also appealed this decision. She argues that he was incompetent to represent the trust's interests because of his ill health. Back in May 2017, Mr. Carr appeared at the initial hearing on this matter. After 3 hours, Mr. Carr announced that he was leaving to undergo a medical procedure. The hearing officer offered Mr. Carr the opportunity to provide his evidence out of order to accommodate his schedule, but he refused. So the hearing officer continued the hearing. According to his daughter-in-law, Mr. Carr refused to attend the continued hearing and also refused to authorize anyone to appear on his behalf. And the second hearing occurred with his absence. There is little doubt that Mr. Carr was seriously ill last spring and summer. He passed away in September. But there is no evidence that his illness made it impossible for him to competently represent his or the trust's interest if he wished to do so, if he had wished to do so. There is nothing in the hearing officer's decision that suggests Mr. Carr showed signs that he was unaware of the hearing's significance or possible outcomes or any sign of lack of mental competence or capacity. His family also appears to have had no reason to think that Mr. Carr lacked the capacity to represent his interests if he had wished to do so. Nothing of that kind was ever suggested in the numerous communications from the family to the hearing department. In fact, the record shows that Mr. Carr continued to manage the property's affairs after the initial hearing. He filed several registration forms for the property in the weeks after that hearing. And when his daughter-in-law contacted the hearings department about Mr. Carr's decision to not attend the second hearing, she said he had decided not to participate. She never suggested that he had done so because of mental incapacity. Ms. Saman also notes in her appeal that the record shows no proof of service that evidences that notice was given to anyone other than Mr. Carr. She is suggesting that there was some lack of due process. But notices of all hearing dates were given to Mr. Carr during his lifetime, who was the owner, and communication from his daughter-in-law proves that he received them. Because the record shows that Mr. Carr and his trust's interests were represented to the extent that Mr. Carr wished to represent them, and there is no evidence that he lacked the mental capacity to represent those interests, staff recommends that the board deny the trust's appeal and affirm the hearing officer's decision.
Thank you very much. There is a question from Commissioner Torosis for staff.
Do you want me to ask them now or wait till the?
There are two chits. I'd prefer that we wait till after the public has spoke, but
To ask staff questions? Okay.
thank you. We have Gina DeBaca, who has asked to speak. If you'd like to come on down the podium here, you've requested 5 minutes, so whenever you're ready.
Good evening, everyone. Can you hear me?
You might have to speak up.
Is that better? Hello? Is
That's
that better?
Yes.
Okay. So my rent was $875. I went to rent the apartment in May of last year, 2016. And then on June, I didn't actually move in. And then June, I went and I gave my cashier's check for the first and last month, which was $875, so a total of $1,750. And I had, Mr. Carr, when I first went to meet with him in May, he was not going to rent to me for any amount. He was going to rent to me for free. My husband worked for him for years. My husband was deported to Guatemala, and I'm here left supporting our two daughters. Mr. Carr loves our daughters. I'm not the only tenant that he has there without paying rent. There's also another unit there that their family, they've been longtime workers of Mr. Carr's as well, and they also have complimentary stay there in the building. So this is something that Mr. Carr was kind enough to do. I personally said, no, I need to pay something. So I told him I would pay the $875. The MAR for the rent for that unit, I have it in here, and I'm assuming you guys have it as well, but I believe it was $873 or $877. I'm off by a couple digits, I'm sure. So I rounded it to $875. He never was pressuring me for the rent, but nonetheless, I paid it. My first cashier's check was June. I was unable to move in until July because his son was painting the apartment. July, I paid another payment August 10th, and that was, I believe, $500, and that was for the month of July because I didn't pay in July. So my August 10th check was for July. And then I paid August 30th, and that was $1,750. That was for the month of September and for the month of August. So I paid cash payments to him, and I also paid in cashier's checks to him. He had no issues with me. Later on, his son was there. I don't know what happened, if his son was pressuring him to start getting rent from myself and from the other unit. I don't know. I can only speculate. All of a sudden, he took me to court, and I believe that was in January. We went to court, and at that point in time, I was kind of fed up with the behavior going on. He was very competent. He was walking into my apartment when I was asleep. He was very competent, and he has a history of this behavior. It happens to other tenants there as well. So we both filed against each other. I filed city attorneys, rent control, and codes enforcement. He filed eviction. I won in court. I'm still there, and my rent is $875. I do believe that his son forged that document. It was filed in June of this year, 2017. Mind you, I moved in a year prior. Nobody filed paperwork then, but now it's in June of 2017. Somebody filed for all of our units, and we don't think it was Mr. Carr because we know his signature, especially me and the other family. We've been knowing him for years, and we know what his signature looks like. I cannot prove that to you. I can only tell you my thoughts and what the other tenants think. So we all received something in October after he was passed away. We didn't know that this paperwork was filed with rent control in June. So all of a sudden, we get these notices with our MAR being different. My MAR had literally doubled. And so immediately I went to rent control and I'm like, what is this about? And they said, no, don't worry about it. They can't do that to you. I was like, okay. And now here we are. And I need to prove somehow that my rent was $875. We did not have a written lease. It was all oral agreement. And that's how Mr. Carr worked.
Okay.
I have some questions.
Okay. Have you said all that you've come to say? Because there's questions that commissioners want to ask you. Okay, okay, that's fine. I just want to make sure you were done. All right, Commissioner Phyllis, I believe, was first.
So, Ms. DeBaca, we heard that you, the record was held open so that you could provide the documentation that you said came from the court, and you did not do that. I was just wondering why you didn't.
Yes, I was kind of frustrated. I was dealing with city attorney's office, who was just non-responsive. I was dealing with codes enforcement, who was very responsive. They were great, but they were so great that they were there so often. I was dealing with the rent control board. I was dealing with him trying to evict me. I was also dealing with his son, who is a veteran, who has a lot of automatic rifles upstairs, right above me, and who was harassing me. So I was dealing with 5 different things going on at the same time. Yeah, I was stressed out, and I was still trying to work. Still trying to go to work and hold down my household. So, yeah.
I want to point something out. If this was after the UD hearing happened, you wouldn't have been trying to be evicted. This would have been done. I mean, that's why the record was closed. So I just want to be very, very clear in understanding. I mean, the UD would have been done. You're dealing with a rent board, and you know that this is a hearing that's going to set your rent, which can be literally a matter of staying in your apartment or not. So I'm just having a difficult time understanding if this is what the court actually said, why you just didn't give us those documents.
Actually, everything did overlap. It was all happening at the same time. It was all overlapping. And no, I didn't think that rent control, because the hearing was not about my rent, the rent control hearing. The rent control hearing was about me reporting how the building was dilapidated. So I didn't think that that piece was even an issue. And I didn't think that they were going to change my rent. No, I didn't think that this was important. I didn't think that they could just change my rent. I had no idea that they could do that.
Okay, thank you, Commissioner Phyllis. Commissioner Trosas has some questions for you.
Do you have a copy of the UD with you today? Because we can consider it. Can you give us a copy of the UD today with you?
That's the one thing I don't think I brought.
All right. Okay.
Yeah, I brought the,
We can't consider it, but I just want, you're stating that it was all happening at the same time. I understand what you're saying. I understand that this is probably a really stressful situation and you're trying to stay in your home. But if you're at a hearing with the rent control board to potentially decrease your rent based on the conditions that you're living in, I think it's relevant as to what the rent is set at and then how much that's going to be decreased. So I understand what you're saying, that you thought it wasn't about that, but I mean, I think it's always about that.
they didn't say that they were going to change my rent. Like, that wasn't the issue there.
Were you petitioning for a decrease in your rent?
Yes, because it was dilapidated.
Okay.
It still is.
So it would be about the rent then,
No, it was about the condition of the building.
to decrease your rent?
Yeah.
Okay.
But not that they were going to change my rent amount. That was not
Okay.
the reason we were there.
And then what evidence do you have to substantiate your claim of forgery on the registration?
Myself, and then also the other unit who's known, that family has known him probably 30 years, and my family's known him probably 15 years.
Is there did you present any evidence at the hearing to show that that was not in fact his signature?
No, I didn't go out and pay somebody that specializes in that. No, I don't have that type of money to pay a specialist to get evidence of proof. There is specialists That's what they do. You have to pay them, and I don't have that kind of money, so no.
Yeah, it doesn't matter because we can't consider them.
I can just give you my, my
Right.
opinion, and I truly believe that.
Did you ever submit a check for $875 to Mr. Carr that you have proof of to show that that was the amount that you were submitting? And is that in the record?
If I could answer that, the one check that is in the record that is of that amount is the last check that we have that is submitted, which is from April of 2017.
Okay, and then how many times were, I think I know the answer, but how many times were checks of $1,750 submitted?
We have two checks in that amount, one that is dated from June and one that is dated from August.
And the remainder are of varying amounts?
Varying amounts, a bit like 100, 200, 500, in that range.
So, I mean, you could see how that might be confusing.
Yes, of course. Usually owners don't tell you can live on their property for free. So I totally get it. Yes, I get it.
And then did you ever have a signed rental agreement with Mr. Carr for $875?
I'm sorry, could you repeat?
Did you ever have a signed rental agreement over and above what was registered with the board for $875?
Our entire lease was oral agreement.
Okay. Thanks.
Thank you.
I have a question from Commissioner Foster for you.
In your appeal and in your testimony, or not your testimony, I'm sorry, your public comment on your item, you indicated that your MAR was 875, my MAR was 875, you all know my MAR was 875. You said that in your initial comments. I'm just curious, because I looked through the record thoroughly, and did you have a document from the Rent Control Board stating, like after you moved in, that says 875?
This one says, no, and I didn't say it was 875.
873, sorry.
It was something close. And this one, because I would get these, mailers.
Sure.
You guys send out. This one in particular says 884, and I have others that I had saved.
And what date is that from?
This one is spring 2017.
Can staff just explain the timing of the notices that she possessed? Was that for a prior tenant, or was that, okay. Thank
Yes.
you, staff.
Yes, when we send the newsletters out and we put the rent on for the unit, it also has a note beside it that says if you've moved in recently, the owner may not have yet registered your tenancy, so this amount may not be accurate, and you can contact the Rent Control Board. So that often happens, and we hear from tenants that the owner hasn't registered the rent, and then we communicate with the owner that they need to do that. And just to address the issue about establishing the rent in the decrease hearing, at the time that the hearing was occurring, the rent had not yet been registered for Ms. DeBaca's tenancy, so the rent in our database was the former tenant's rent. And in order for the hearing officer to be able to determine what the maximum allowable rent is with the decrease in effect, the threshold issue is what is the lawful maximum allowable rent for the unit to start with. So that's why the hearing officer had to make that determination, so that then she could determine what the rent will be with the rent reduction in effect.
Commissioners, if I could also, in the hearing officer's decision on page 4, when the hearing officer is discussing the procedures that were involved in this case, the second to last paragraph, she said, the hearing officer had repeatedly instructed both parties, this is after the first hearing, or actually at the conclusion of the first hearing, to bring documents or other evidence regarding the initial rent levels for the unit. And by the end of the second hearing, the only documents produced were some rent checks submitted by Ms. DeBaca at the first hearing. So Ms. DeBaca stated at the second hearing that she could submit documents from the eviction action that would establish the initial rent. And the record was held open by the hearing officer for a week following the hearing for the purpose of the submission of those documents. But she never submitted those documents.
Thank you. Any other questions? No, there's another chit.
They haven't testified.
Any other questions for Ms. DeBaca? Okay, thank you very much.
Thank you.
I understand. I do have a question.
Okay, there is one more question. Commissioner Phillips, please.
So I'm just trying to understand, sorry, I don't have like a buffer on my mic like everyone else does, so it's like really loud. There's a multitude of checks between August and January 2017, August 2016 to January 2017, that are in much smaller amounts, 500, 250, 100, 100, Why were they that amount?
Because I get paid in invoices, so I don't have a steady paycheck. I don't work for a company where I get a paycheck every week. I get paid in invoices. So, and he knew that, and so when I get paid is when I would pay him. And yes, I would pay in small increments. And I did pay him in cash as well. He loved to be paid in cash. He was very old school. He liked cash. And I think I did submit, I don't know, I believe I submitted because I do actually have notes from him stating to pay him in cash. I literally have handwritten notes from him. And I don't know if I submitted that either at the rent control hearing. But I did pay in cash as well. So go ahead, I'm sorry.
Sorry, how much money did you pay in cash?
Well, it depended on the month. So if I have a cashier's check, I'm just throwing numbers out there, I'm not looking at anything right now. If I paid $250 one month in a cashier's check, as soon as I was able to, then yes, I would pay him the remainder in cash.
So, I mean, I'm just trying to understand this record, right? Like, you have a August 30th check for, you have a June 2016 check for $1,750. You say
Yes,
that's for
first
2
and
months,
last.
right?
Right.
Okay, so first and last. So then you have an August 30th check for $1,750, and you said that was for 2 months.
Yes, for August and September, yes.
Okay, August and September.
Yes.
But then you have an August 10th check also for $500. So
That-
why did you?
That was for July. I didn't pay July. That was for July. I was trying to play catch up.
But why would there be 1750?
So there's no, so
So I was
June
late.
1st and last, and then on August 10th, you went back and you said, I'll give you 500 for July.
Yes.
And then August 30th, you were like, I'm going to get ahead. Okay. I'm
Because
just trying
whenever
to
I get my invoices, if I get a large invoice, then I'm getting paid, let me hurry up, let me pay my bills.
I mean,
and-
because,
Because once the money's gone, I have to wait for the next job. I work for myself. I'm self-employed.
so just for my fellow board members' benefit, the reason why I'm trying to figure out like what these amounts were is she was here for about what, June to April is like the amount of time we see payments for. And over that amount of time, we have at least receipts for cashier's checks, at least by my estimation, it was, I think, in the amount of about $5,500, right? So if you divide that over 10 months, that's around $550 per month, which is much closer to the $875 range than the $1,750 range. So, you know, in terms of if she's supplementing it with cash, and that was the agreed upon, it just looks like there actually is somewhat of a record showing it was closer to a 3-figure amount than a double that amount. I'm just, and I'm trying to understand if I'm missing anything. So thank you.
Thank you.
Thank you very much. I have another request to speak from a Stan, and I'm sorry, I think it's Peckler? Mr. Peckler, if you would like to come, you can go down. You can sit down now. Thank you.
so much.
Should we just send something? He didn't.
Whenever you're ready, you've requested 5 minutes.
Yes, good evening. I'll be brief, and I won't take up the whole 5 minutes. I represent the trustee in this matter, and the trustee is no longer pursuing an appeal. So the trustee agrees with the determination of the board and the recommendation that's currently, that was in the tentative. I wanted to address a couple of points made by Ms. DeVaca. As she said, and I'll quote a few of her statements, that she cannot prove what she's trying to prove. She said, I don't know how, but I need to prove it, that her rent was lower. I was too busy, and which is not an excuse not to provide evidence of the rent, right? She had her hearing. The record was open to provide evidence. She didn't provide that. She had an opportunity to provide evidence from the eviction as well today, and she said, gosh, that is the only document that I did not bring today, which is the most important document. for this matter, and she did not bring it. There's a statement that the landlord promised her free rent. There's no evidence of that. There's no evidence of forgery. Nobody to testify regarding signatures. There was a statement that the signatures look similar, and of course we agree. And then the statement regarding, he preferred cash, but she continued to pay check. It just doesn't make sense. So in order to prevail in the appeal, Ms. DeBaca would need to establish either legal error or the factual findings were not supported by the evidence. We believe that the factual findings were supported by the evidence and there was no legal error in the underlying matter.
Have you concluded your comments?
Yes.
Okay. I have a question from Commissioner Phyllis and then Commissioner Flora.
Mr. Solznick?
Peckler.
Pecker, sorry.
Peckler. Yeah. P-E-K-L-E-R.
Okay. Did you represent the estate in the UD action?
I did not. No, I'm appearing specially on behalf of the attorney that did.
Do you understand, are you familiar with what happened in the UD?
I'm not. I was asked to appear here today to ensure that Ms. DeBaca does not bring new evidence, which there is no new evidence today. And so I was asked to appear, and if there was a statement to address those statements. But seeing as Ms. DeBaca did not provide any new evidence, we just asked that the
I mean,
slip stand.
it would be very helpful for me to know, obviously Ms. DeBaca is still living in the unit, so we draw from that she was not evicted, which gives some credibility to her statement that the landlord agreed with her that there was, the judge agreed with her that there was no non-payment of rent.
Hang on, sorry. Does somebody have a phone on or is it outside? Oh, it's in it.
Yeah, can you
Sorry, it's just a little distracting. Thank you.
So
Sorry about that.
we're just trying to, I really am trying to understand. That's a critical component, right? And the fact that she's still in the unit and the fact that it doesn't appear that she was evicted does tend to suggest that if the UD was initiated for non-payment of rent, she's still there, and the UD was based on, an amount of rent which the landlord is now claiming is $1,750 and she says was $875, it would be enormously helpful to me to have someone else give a little bit of information about what the heck happened there.
May I just
Please,
take-
Councilor, please.
As with any appeal, the question is not whether there could be evidence out there by which the record could be supplemented to cast the decision in a different light, but whether, based on the decision that was before the hearing examiner, there was a legal error or the findings made were not consistent with the facts as actually presented. And again, the hearing examiner made every effort. The issue of the UD was put into play by Ms. DeBaca herself. She was the one who claimed that there was a UD. There was no other evidence of that occurring. He said that.
I'm deducing, but we're allowed to deduce from the record. That the facts are in the record. She was not evicted, and the facts are in the record that she. So even without any supplementation, which we obviously don't have because Mr. Pecker doesn't have anything, Mr. Baca has said she doesn't have anything, we can deduce from the facts in the record.
Reasonable deductions, yes. Again, the law provides for a rebuttable presumption of the accuracy of the registration. So it has to be found that the evidence that was in the record was sufficient to rebut that presumption as well. So I just wanted to just remind everybody that there is that. Thank you.
Thank you very much.
I
Okay.
have some questions for him.
Yes.
I have a
Hang on,
question.
okay, wait, hang on one second. Let me gather my thoughts. You're still on the podium. Commissioner Flora, I have
Yes.
questions for you.
Can I
Did I
just
hear-
make one comment? Actually, I should make that clarification. before maybe you answer, if you don't mind. Because there was a question there, and I just wanted to address that. Just
Okay.
really,
Back to
really
her
briefly.
question?
Yes.
Sure, go ahead.
I apologize, and thank you. Mr. Lewis responded better than I probably would have. But to address your point regarding the UD, because I was not involved in the underlying matter, I'm not as familiar with everything that transpired, aside from my conversation with the attorney and what I read. I'm not aware whether there actually was a UD. I was going based off of what I read in this matter, and that if there is a UD, there's no record of it. And so if Mr. Baca even provided a case number, we might be able to locate it. But I'm not aware, actually, I don't have personal knowledge of a underlying UD that took place.
Okay.
That's not in the record.
Okay, we have Commissioner Flora.
Yeah. Did I hear you correctly at the beginning of this? Did you say that the trust is no longer appealing for a new hearing?
Correct. The trust agrees.
We're sharing paperwork.
Oh, I apologize.
So that is correct?
That's
So
correct.
the sole issue here is the rent?
Correct.
All right. Just because I've got you here, and I know the issue is the rent, but since you're representing the trust, would you at least stipulate for us this evening an admission that you got quite a bit of work to do on this unit?
I apologize. I'm not able to stipulate to that.
Yeah, really? Do you know how large a rent decrease? Do you know how bad the condition of something has to be to warrant a $790 rent decrease? I'll answer it for you. Pretty damn awful. And since I've got you here tonight, regardless of how we decide on this item, I'd like you to pass on a little message for me to the people that are taking care of this building. And that message is, take care of this building, because a $790 rent decrease, you should be embarrassed.
I understand.
Absolutely embarrassed that the person has to live in this condition. Thank you.
Okay, and I have Commissioner Foster who had questions for you.
It's a question for the speaker. There's nothing in evidence regarding a written lease, and the tenant has testified in her hearing and then also spoken here tonight that there was no written lease, that it was an oral agreement. Does your side, or does your client, or does the family trust have anything in the way of a written agreement that the late Mr. Carr wrote with any of his tenants?
I'm not aware of any written agreements.
And how many units total are in the property?
I apologize. I'm not able to answer that question either.
Does staff know how many units are in the property, or if there were any other?
Yeah, let me see.
And you just stated that there were not written leases with any of the other tenants, which could show a pattern.
I imagine that if there was a written lease agreement, it would have been provided in the underlying action, and I don't have.
And then if
one
I could
with
ask
me today.
staff a clarifying question. In other cases I've sat on in an appellate manner, we have often cited from the charter that in the absence of definitive proof, we have often taken the aggregate of the first year's actual payments as evidence of what the established rent, the established MAR is. Isn't that correct?
Not exactly, no. A unit's maximum allowable rent is the amount, the base rent from which the maximum allowable rent is determined, is the amount actually paid in the initial lease
That's what I
term.
mean, in the initial year. So if
And
the
so it's not a
amount she
question
actually
It's not a question
paid-
of evidence. It's not a question of, you go with whatever. It's not that you look to see what you have, like, council checks for. It's what was the amount that was actually paid. And here, one side said this amount was paid, and the other person said the amount was paid.
Wait,
So-
did the Carr Family Trust put forth evidence that a certain amount was paid? I didn't understand it that way.
Well, that
But
was what the hearing examiner determined.
Okay.
That was-
So here's, if I can summarize the evidence as I see it, it's like two.
Wait,
hold on.
no.
Oh, sorry, are we
Ask
entering?
my question.
We're
Sorry.
in discussion, but you could hold that, and then she's
Yeah.
got questions for Mr. Peckler. Are you
Okay.
done with your questions?
I am, thank you.
Okay. Commissioner Terosas, questions for you, Mr. Peckler.
Okay, so Mr. Peckler, obviously I just went through the record to look at exactly how many checks were submitted and in what amounts. There's only 2 checks for the $1,750. All of the rest of them are 500 or less, with the last one obviously being 875. How do you explain that, and where was the rest of the money coming from for all of those months if, in fact, the MAR was 1750? Why wouldn't you have taken action sooner?
I apologize, I don't have that information today.
So you can't answer any questions about anything in the record here?
I'm here to address what was in the recommendation.
Yeah, but I mean, this is on appeal, so you have to be able to speak to whatever's in the underlying record, and it doesn't seem like you're able to.
I can address that. Ms. DeBaca has not alleged that there was any legal error, and she has not provided any facts to support any legal error in the underlying action. In addition to that, there's not sufficient evidence or not sufficient testimony or evidence to show that the underlying action was not reasonably, the decision was not reasonably supported.
Do you have any indication as to how much money in cash payments you were receiving such that the 1750 would have been received in all these months where we're seeing checks of $500 to $100?
I do not at this time.
Okay. Is anyone else here that can speak to that on your side?
No. If the board is so inclined to reschedule the hearing, I could obtain the additional information and have a person here who does have personal knowledge.
I mean, I would just let your landlord know that it's poor practice to come to a hearing without someone who's fully informed as to the underlying record.
I understand.
All right. Any other questions for Mr. Peckler? Okay. Thank you, Mr. Peckler.
Thank you.
Okay. That is all for the request to speak. Now I'll open it up for discussion on this matter. I know that Commissioner Foster asked to be placed on the list, so I'll put you're on the list as well.
Thank you. So the staff report is thorough and it is complete, and for me that's not what is at issue here. And only very rarely do I hear something or read something or evaluate something on my own that brings me to sometimes a drastically different pattern of thought, or I'm at least wanting to hear what my fellow commissioners think. Whether or not there's evidence of a UD, whether or not things were brought forth in a timely manner, does not necessarily supersede another reasonable explanation of the same set of, or another reasonable conclusion of the same set of facts. The fact is, she was not evicted by anyone, and if there was a UD proceeding, she must have prevailed because she's still in the unit. And if there's no evidence of a lease for the amount in any event, what the charter, sorry, I'm not supposed to use the word evidence, a total aggregate of the amount paid over the course of the first year, or in this case 10 months, is supposed to be representative of what the actual rent has been, because that's what was accepted by the landlord. And if there are no other written leases on any of the units, and there's potentially another unit that's also not paying rent, who are we to say that a landlord didn't simply let someone stay in a unit? There's no law against that. There's no law against just letting someone stay in a unit. There are some laws, though, that regulate hot and cold running water and functioning utilities and housing services in that unit. So she was awarded a decrease based on those provable things. I can imagine a scenario in which a benevolent landlord decided to let someone live in sort of a shabby apartment for free until the living conditions became untenable. And while there's, you know, someone who owns a building doesn't have to take an owner occupancy exemption, nor does a landlord have to collect rent if they don't want to, nor does a tenant have to complain about living conditions if they don't want to. None of those can be compelled. They're all voluntary, and the time frames are voluntary. So the condition of the apartment's not an issue for me. The amount of her decrease is really not an issue for me. What seems to be compelling to me is that if, in fact, there was any UD or any complaint of non-payment of rent, it didn't go anywhere because she's in the unit, and the totals of the checks equals grossly under $1,750 per month, like Commissioner Phyllis pointed out earlier. So I'm interested in hearing what my fellow commissioners have to say, because I'm finding myself arriving at a different conclusion from the same set of information.
Commissioners, if I could just make one comment, Commissioner Foster, something that you just mentioned in terms of the aggregate for a year. What you're referring to in the specific language of the charter is not for a year, but it's for the initial lease term. And there is no evidence that there was a lease term of 1 year in this instance. It was an oral agreement. So it'd be reasonable to deduce that it was actually a month-to-month tenancy. And so that's the reason that the hearing officer went in the direction that she did in her analysis.
And thank you for that clarification. And again, I think the staff report is complete. And I do see exactly how you could draw this facts. I just am also seeing how you could draw a different inference from the same set of, or lack of, information. So I'm going to yield to the next commissioner.
All right, now I've put myself on the queue, so let me say a couple of things, then we'll go to Commissioner Phyllis. I have read through this, and there is a statement that's made in this report that said the staff believes there is no basis on which to overturn the hearing officer's conclusion that Ms. DeBaca's initial rent was $1,750. I don't agree with that. However, as I understand, the standard of review for us is whether the hearing officer made an unreasonable decision based on the facts presented to them. And in reviewing all of this information, I don't see that the hearing officer made an unreasonable conclusion based on the evidence that was there. There was ample opportunity for Ms. DeBaca to provide evidence, for example, of the forgery, to provide some other type of evidence that the rent was something other than $1,750, and was unable to do that for, she said there may have been several reasons that precluded her from submitting the paperwork timely. But this matter was serious, and she just didn't do it in the time amount that she was allotted, and ample, and even more time was given for her to provide the information to the hearing officer, and she still didn't do it. I don't agree with the staff report in total, but I think because, as I understand it, and counsel can correct me if I'm wrong, the standard with which we are to review this is whether the hearing officer's conclusion was unreasonable. And on the facts and on the testimony we've received tonight, I don't see it as being unreasonable. So, Commissioner Phyllis, you've asked to speak.
I see our general counsel playing with that microphone, looking like you want to tell us about. Oh, no, okay, I wasn't. So I do want to be clear about the standard of review. The standard of review is we must adopt, or we defer to the hearing officer's decision unless there's no reasonable basis on which to sustain the decision. Is that a correct characterization?
Yes.
Okay. So I want to tell my fellow commissioners, that's an extremely high burden, but I'm going to tell my fellow commissioners why I think it's sustained here. And I am inclined to reverse the hearing officer's decision. So at least as I understand it, the key pieces of evidence are this. We have an initial registration of rent at $1,750. It appears that was I'm not persuaded that that's a forgery, so I'm going to assume that was an initial registration of rent at $1,750. Not buying the forgery part, right? That creates a rebuttable presumption that the rent was $1,750. So then we have to look at what evidence do we have in the record that actually rebuts that presumption. And the key evidence in the record that we have is we have oral testimony of a UD, which hasn't been rebutted by the landlord, and we have these cashier's checks, right? Which only 2 of which are in the amount of $1,750, which are spaced out between first and last month's and then it does appear to be a roughly 2-month window. And then the overwhelming majority of the remaining checks are in significantly lower amounts. If we look at over a 10-month period, the total aggregate, I think, was 55.75, which if you, believe Ms. Tabaka's story about supplementing with cash, makes it, to me, far more believable that she's getting to an $875 rent over a 10-month period than somehow she's been supplementing with like a massive flow of cash, far more than these cashier's checks, and it's up to $1,750, and she's been able to defeat this UD to demonstrate, the evidence in the record, to me, it does meet that threshold of saying, like, there is no reasonable basis on which to sustain this decision because the cashier's checks and the testimony about the UD are strong, have not been rebutted. So I welcome hearing from my fellow commissioners on where they're at. And I do want to, express, understanding with the representative from the landlord. It seems like you've been put in a tough spot tonight. There's not, the record is sealed, so it wouldn't really have mattered if you had brought evidence anyway. We couldn't consider it. But, I do appreciate that sometimes, you're here to continue it. So this is a reflection on what is in the record and not.
May I
the
clarify
lawyer
one
that
thing
serves
about the
tonight.
record? Mr. Chair?
Please, yes.
About the UD, the testimony was not that the landlord filed a UD for not paying $1,750 when she was paying $850. The testimony was just, there was this UD, and that UD will show the amount of rent that what my maximum allowable rent was, and I'll provide that document, and I didn't. So there was no testimony back and forth between the parties at the hearing about what the basis for that UD was. So.
Okay, wait a minute. Commissioner Crowe.
Did the landlord ever state on the record that he had initiated a UD?
No.
Okay. And the other thing that just kind of came to my attention as I was looking at this again, so we know that Mr. Carr passed away. Oh my God, this is so aggravating. Is this on? I don't even think it's on. We know that Mr. Carr passed away in September of 2017, correct? Okay. This vacancy unit registration form, we have a date stamp on. It says June 13, 2017. Convenient that it was filed in 2017 when the date of the new tenancy is reflected as July 7th, 2016.
Mr. Carr filed it after the first hearing, in fact.
Okay, so he conveniently decided that was potentially decided to file it with no written lease when the record also reflects that he was suffering from dementia.
The record doesn't reflect that, and leases are not required in registrations and are rarely provided.
Sure, but no, I understand that. Sorry, I wasn't trying to insinuate that the leases were required. There is an email on the record that states that he was suffering from dementia.
No, there's nothing in the record that shows that he was suffering from dementia. That was a claim that was made by an unsworn claim
Okay.
made as part of the appeal.
Okay.
The record does not include evidence of that.
Okay, but I will say that it does state in the staff report that the initial reason that they appealed was because they thought that he was incompetent to represent the interests of his own interests.
That's what they said in the appeal,
Right,
which they
okay.
have not withdrawn.
Okay,
Yeah.
and he has this shaky signature here, with handwriting, which I'm not a handwriting expert, that doesn't match a shaky signature for something that was filed a year after a tenancy began. Yeah. It's in your packet. I just started looking at the dates. Okay, I just wanted to kind of flag that as something that seems a little interesting.
Okay, thank you. Any other commissioners would like to engage in discussion? Yes? No?
Yeah, I have a question for
Okay.
staff.
Okay.
So, and with the timestamp being 10 or 11 months after she ostensibly took possession of the unit, and you said a lease is not required, I'm still kind of going back to taking the total evidence I'm not supposed to use the word evidence, taking the total available information of the total accepted by the landlord. We have her testimony that says, I gave this much plus cash. We have no testimony to the opposite. So there's an absence of any testimony that refutes that.
Right.
And the sum total of her checks, and even her, she's offering that she gave more in cash, still, I agree with Commissioner Phyllis that the total would seem to reflect a total much closer to $875 than $1,750, and there's no evidence from the landlord's party of anything having to do with $1,750 until a year after she'd been living there already. So, I mean, a lot of this is very troubling, and I respectfully disagree with the chair that I think I can draw a different conclusion from the same set of facts. And it's not, again, it's not that staff did anything wrong or that their conclusions could not also reasonably be reached. It's that I'm reaching a different conclusion.
May I just clarify about something about the record?
Yes.
Oh, I'm sorry.
I do want to speak to that because
only if it's
we
a
have to be
legal error.
really, really clear about this record. Like, if you think staff's conclusion is reasonable, you have to affirm.
Right.
Like, we have to find that staff's conclusion was completely.
Well,
wait.
Go ahead.
You have to find that it was unreasonable. So when we make this record, if there's an appeal, we have to be very, very conscious. Like, we have to say staff's finding was unreasonable. Here's why it was unreasonable.
Okay.
And not that we could,
No, I
not
understand.
reasonable minds disagree. So
Right.
I do want to draw attention just to one thing in the record, which I think is really important. So this vacancy unit registration, which Commissioner Tarosis pointed out was on June 13th, appears to have had at least 2 people working on this, right? Because you see Mr. Carr's very, very shaky handwriting, and then you see very clear handwriting from someone else. We don't know who it was, but I think we can reasonably infer that there were 2 people working on this and that Mr. Carr may not have put in that 1750. Mr. Carr may have just signed this document. And I think that further supports finding that the hearing officer's conclusion was unreasonable. And I am loath, really, I mean, you know, this is a very high standard for deference, but I do think that the conclusion here was unreasonable and cannot be supported by anything in the record.
Well, to
Mr.
continue,
Well, I'm sorry, Mr. Lewis, did you want to say?
I just wanted to clarify one thing about the record, just that there is no evidence of the amount of cash that was paid one way or the other.
Correct.
I mean, there was no, even tonight, Ms. DeBaca didn't say, and here's the amount that I paid, so.
no, I understand.
So just
But
to clarify.
So from the facts and evidence, the average amount over the 10 months in question is only $550, which is below.
That's the point that I'm making. There's no evidence of what the average amount was because there was no
consistent.
evidence of what the cash amount was.
Okay. Well, but there's nothing anywhere close to 1750.
Well, except for
Well,
what's written on
of checks.
on the vacancy
The testimony
unit
was that rent was paid partly in checks and partly in cash, but there has been no evidence presented of what the cash amount was. So you couldn't just look at since the testimony is it was paid in these 2 forms, you can't just look at one form and say, this is the rent.
All I meant to imply by that was that it's if it's going to err in one direction or the other, it errs in the lower direction and not the other direction. That's the only point I was trying to make. It wasn't a very scientific point, I concede. But so one of the problems I have with the staff report is, and I'm having trouble finding it now, is where the hearing officer, where is it? It took their own inference, it looks like, that because she only moved in July, then that definitely means that some check was for a specific 2 months, and that the hearing officer was inserting their own opinion as to what months a check represented, which is in opposition to what the tenant said.
That's not exactly right.
Where, can you help me find it?
Yeah.
I had it earlier and I've lost it.
Are you talking about the staff report or the hearing examiner's decision?
I'm sorry, I can't locate it, so
It will, in the staff report, it mentioned that Ms. DeBaca had a number of different, she testified inconsistently about when her tenancy began and what the rent check periods were for. So she said that she rented the place in June, but that she didn't move in until July. Then
Correct.
she also talked about renting it in May. And so one of the things that the hearing examiner looked at was that there was such an inconsistency of testimony about when things occurred and what.
I think I understand what you're
Right,
saying.
okay.
So in the absence of a lease, in the absence of anything to the contrary, and with the amount of the checks and the testimony we have, without any rebuttal to her argument, I'm still finding error in the conclusions of this report. And I'm inclined to overturn,
Okay.
because I do find error.
All right, and Commissioner Trosis?
Yeah. I mean, listen, I think it's deplorable that you have conditions where they're so bad that they would warrant an over $900 rent decrease. I think that it's somewhat embarrassing that the landlord brought someone who can't speak to the record when that's clearly the only thing that we're considering here. And honestly, I think it's really unfortunate that we have zero evidence of a UD, because I think that absolutely would have changed this entire situation. But I don't necessarily think that there was a legal error committed here, because I think the burden was on Ms. DeBaca, to bring some sort of evidence of the UD, or some sort of evidence of a forged signature, or some sort of evidence with cash payment. I mean, any sort of documentation. None of it was provided. And although I think, this does not necessarily seem like the landlord was operating in good faith, I think that it is possible that a reasonable person could have made this determination. So I would have to say at this point, I would probably sustain the underlying staff report, or the hearing officer's decision, excuse me.
You mean
Yeah.
affirm the,
Yeah, excuse me.
okay. And I see Commissioner
I
Flora.
sustain, not overrule.
Gotcha. Thank you.
And I would be, very much lean toward the same. There are things that we would really love to be true, and I'm right there with you in loving and hoping they were true. But, our hearing officers are very good at what they do, that they know the law, and I don't think there is a legal error here. There are things we wish were true, there are things we hope that are true, but then there are things we cannot prove. And so I would second any motion to uphold the hearing officer's decision, finding of facts and conclusions of law.
Okay. Well, do you want to make that motion?
I move we uphold the findings of the hearing officer and findings of fact and conclusions of law.
Is there a second?
I guess I'll reluctantly second this, although there's no legal error.
Well, I take no pleasure in it.
Right,
I'm saying what I think we
I
can
wish
legitimately do.
Right. I mean, I wish there would have been one piece of evidence to substantiate any, even.
Yeah, I take no pleasure in it.
Right.
But
All right,
that's the motion,
so-
and
Yeah.
Motion and second?
Second.
Commissioner Trosa seconds. Okay. We'll take a roll call vote.
No.
yes.
No.
Yes.
Yes. Okay, moving on to, I believe we are at 12B, number 2, 10B2, excuse me. Can we have a staff report, please?
Commissioners, tenant Jose Davila filed a rent decrease petition for which the hearing officer granted him a decrease for water leakage under the dining room and bedroom windows and reduced landscaping services. The owner, Ms. Kim, has appealed that decision. She argues that the water leakage has been fixed as evidenced by an invoice from a contractor dated July 15th, 2017 that she submitted to the hearing officer. Mr. Davila, however, testified at that same hearing that after the repairs were completed by the contractor, water has kept leaking in and yellow stains have appeared under the windows in the main bedroom and dining room whenever it rained. The discoloration and water-stained paint in these locations were confirmed by the hearings investigator, Pete Savino, when he inspected the property in August of 2017. Based on that evidence, the hearing officer concluded that the repairs by Ms. Kim's contractor had not eliminated the source of the leakage and granted a decrease. Her decision is supported by the record and is not refuted by the invoice from the contractor that Ms. Kim had submitted to the hearing officer and which she considered in arriving at her conclusion. Ms. Kim also states that she has since hired a gardener to install sod in the front yard. She's claiming to have complied with the hearing officer's decision, but to restore the rent decrease because of compliance, she must request verification of compliance by contacting the hearings department, not including it in her appeal. Staff therefore recommends that the board affirm the hearing officer's decision.
Thank you very much. I have a request to speak from, Young Tae Kim? Young Tae Kim. Mr. Kim, if you would come to the podium, please. You've requested 5 minutes, so whenever you are ready, take your time.
Can you guys hear me now? Okay. So I was directly involved in this situation when I first got a call from the Santa Monica rent control, Laima. So that was the first time I got a call from her. And the reason she called me is because my mom asked Laima to communicate with me the remaining issues that needs to be completed. So Laima clearly communicated to me the 3 outstanding issues, which I still remember very clearly. So one of them was the bar railing on the stairs, which leads up to the room, like this here, that needs to be replaced. The second one is the lighting fixture hasn't been fully installed. And the third one is the wood in the garage hasn't been replaced. It's like some old wood just needs to be replaced with new wood. So I was very clear of the things that we need to, that needs to be done. So we provide the notice to the tenant for Sunday. So we arrived on Sunday, but the tenant did not refuse to let us in because it was a Sunday and he had some visitors. So he said Tuesdays will be fine. So we were frustrated at the time that we couldn't repair it at that time, but we agreed to for Tuesday. So we arrived on Tuesday. So we understood the 3 things that need to be fixed. We fixed those 3 issues, and I was there at that time just to make sure we completed everything. And I also talked with the tenant as far as is there anything else that needs to be fixed. So he did mention something about the exterior. There's some outstanding exteriors, but not the interiors. No other mention of the interiors. So the exterior issue was the landscaping. So that one we decided just to hear the final decision regarding that. And the other ones regarding the backyard. There's some poles and some other tenants' personal property, but it looks like they didn't decide not. The final decision was they didn't decide to require us to remove that personal property. So once we got the final hearing about the landscaping, we remediated that very quickly. So if you go to the property right now, it's replace it with sod. So we're going to submit that verification of compliance very soon. So second, the water leakage, we did not get any notice of the water leakage from neither the Laima, which was Santa Monica Rent Control, nor the tenant. So the tenant didn't mention any of the outstanding issue regarding the water leakage. So I am personally shocked. But I'm here today that if it's still a remaining issue, the tenant can request for repair, and we're 100% committed and make sure that we make sure it's completed. So based on the hearing officer's decision, I strongly disagree with that because I was there at the time we finished repairs, and I looked at the property, the conditions, and the last time I was there before that was like 2 years ago, and it was a mess. Like the ceiling was falling down, there's carpets. We made some significant renovations, pretty much. So if you asked it, is it habitable right now? I would say yes, I would definitely live in it. So I didn't see any discoloration of the ceiling, water leakage, no. So yeah. So that's all I have.
Okay, thank you very much. Commissioners, are there any questions for Mr. Kim? Okay.
No
Oh,
questions.
no? Okay, no questions. Thank you very much, Mr. Kim.
Okay, thank you.
All right, there are no other requests to speak, so
Wait, can I just ask a question actually?
of Mr. Kim?
Yeah.
Oh, okay. Sorry, Mr. Kim.
So,
Commissioner Trosas has a question.
so just quickly, if the hearing, excuse me, if the investigator came in August, are you alleging that conditions have improved
we
since
weren't-
August?
We weren't, well, I can't speak what happened before September because I didn't get a call until sometime first half of September.
Why does it say August?
So,
Yeah, okay.
yeah, so we weren't aware of the senior officer of their decision regarding that, so.
So are you saying that you've improved conditions since you were originally notified?
Well, I don't know when, the thing is, I don't know when we were originally notified. So I was directly involved starting mid-September.
Since you've been directly involved, has anything happened with the water leakage or reduced landscaping to improve those conditions?
Well, we improved the landscaping, but the water conditions I wasn't aware of.
Okay.
And the Lima didn't inform me about the outstanding issue regarding the water
I mean,
leakage.
it's pretty clear right here. Okay. Oh, go ahead.
I was just going to say that a $60 rent reduction was granted for the water leakage, so it was part of the hearing officer's decision that was issued on November 7th, which you've appealed, or which
Correct.
your mother has appealed. So
Correct.
that would be your notification that there was a problem with water leakage still.
And there are photos in the record of leaking water.
Right, and so that's why we hired a licensed and bonded contractor to fix those. So
Okay.
once we finished that, and we didn't have any issues with tenant regarding the interiors, we were under the impression that we fixed those issues. So-
Right, so once you fix the issues, obviously the tenant would be required to, once they've been found to be repaired, required to pay the full rent.
Right.
Okay.
That was under our impression that they would be required to pay the full rent because
Okay.
we were under the impression that it was fixed.
Maybe you can give me some.
And so you said you're going to submit the request for compliance
For the
so that we
landscaping.
can verify that that's the case.
Yes.
Okay, that's
Okay.
the next step.
Thank you.
Thank you, Mr. Kim.
Okay.
Okay, no more questions for Mr. Kim. There's no other requests to speak. We'll open it up to discussion. Commissioner Phyllis?
As we know, this is an appeal, and the appellate standard is incredibly high. I think there is, the hearing officer's finding was reasonable, therefore we have to affirm. I do want to thank, just before I make the motion, Mr. Kim and Mrs. Kim, it sounds like you've made a lot of improvements to this property, and that's exactly the type of landlord that we like to see, that you are taking care of your property. So thank you for doing that, and I know the board will look forward to receiving your notice of compliance. So it seems like you're doing this in good faith, and that's nice to see. That said, I think we do have to affirm based on the record, and we look forward to the notice of compliance. I move that we adopt the hearing officer's finding of fact and conclusion of law.
Second.
Okay.
Third, fourth, and fifth.
Been a first and several seconds. We'll take a roll call vote.
Yes.
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 Yes?
Yes. Okay, moving on to, I believe we're up at item number 11, the public hearing. And this is regarding amendment to Regulation 3105, respecting voted indebtedness, and in parentheses, United School District and Community College District surcharges.
So I have a point of order, a question, before you start the item. And this may not be super popular, and I don't know that it'll succeed, but I would propose to table this until next month. And the only reason I would do that is because, not because we all, and all members of the audience, don't have a ton to say about the subject, but it's that the direction last month was very specific and a little narrow in scope, to where the resulting staff report is only about one category, the voter indebtedness, and it does not take into account the other pass-throughs that are considered property tax pass-throughs of a different type. But yet, I do feel that they're all part of the same conversation. And it was my understanding that if we're to, that it's not just about hearing from the public tonight, but it's also about discussing proposed regulatory language in the staff report, and I just don't feel that we can do that without taking the other things into account. Like I said, may not be a popular notion, but I'm making a motion to table it.
Okay, so Commissioner Flora and then Commissioner Phyllis.
I did also want to make a point of order. I wasn't going to go so far as to move to table the entire item, but I will say that, and forgive any confusion I may have had, our constituents, but what I thought we were agendizing was a first discussion of what we would discuss in a public hearing. And when I read the report, it looked like something was being proposed where we had to be making decisions. I know I'm going to need more than one meeting on this to be able to vote, so I would certainly encourage us that if we want to introduce the item and begin the discussion, that we certainly not make any decisions tonight on what action to take, and that we can look at these this month as well as next. But I'm certainly not prepared to vote on anything that's been proposed. I thought we were, as we normally would, I thought we were agendizing a discussion of ultimately what would turn into a public hearing. And it seems that we've skipped that step this time, and I wasn't sure that. I wasn't sure. I didn't realize that that may have been what I voted for in supporting my fellow commissioner's motion to agendize it. It certainly wasn't my intention to agendize it toward a decision in December. So that's just something I wanted to make very clear.
Okay, thank you. Commissioner Phyllis.
I want to express my frustration and opposition to the motion. I think we've been talking about this since October. It came up again in November when we talked about retrofitting. This is exactly the kind of foot dragging that I think is a huge problem. I think that there is a way to have a meaningful discussion of this item without arriving at a decision. I think it's a mistake to table the entire item, because if there are opportunities for us to provide feedback to staff on broadening the scope of the report or particular recommendations, I'm perfectly willing to agree with my fellow commissioners not to, I think it would be helpful to have more public feedback, but I think it's an enormous mistake to table the item without having meaningful discussion. I strongly oppose it. And I strongly encourage my fellow commissioners not to table the item, because I think I have, look, I know we're all extremely busy people, but, I've put a lot of time into this item and thinking about ways that we can give feedback to staff to come up with a better item coming back next month. And, I don't understand the benefit that would come from tabling it entirely.
Okay.
I just wanted to respond.
Okay, hang on one second. We're going to go in order. Commissioner Terosas, go ahead, and then Commissioner Foster can respond.
I would state that I'm in strong opposition to the motion as presented. I happen to be the one that was ready to meet on Saturdays. I think that we cannot continue to drag our feet. I think that in initial discussion, when we have the opportunity, we're all here, it's a public meeting, we're together, we need to start this discussion, we cannot wait. These are just opportunities for us. There aren't that many opportunities for us, all five of us together, to give direction to staff to make this better and more comprehensive. And if that is the direction that commissioners would like to give, that's great, but I think we need to start the discussion. I have serious concerns about our lack of information to the public on retrofitting, on pass-throughs in general, on all of the items that we've been discussing since October, and I think it behooves us to be abundantly clear and open and give information to the public. So I would like to start this discussion today.
Okay, so I'd just like to respond.
Foster, go ahead.
So first of all, I did not think for a millisecond that this would be a popular motion, and I was not intending any offense to the public or anyone else. I don't appreciate the characterization of foot dragging. I campaigned on this issue way back in 2016, and I've also been researching it for over a year. So I just don't want my fellow commissioners to think that I'm foot dragging or dragging this out or not wanting the public to hear what we have to say. Of course, I want the public to hear what we have to say, and I fully expected that my motion would probably fail. Again, it's not meant with offense or foot dragging. It's simply a point of order that the scope of the direction was narrow, and I just didn't know if we should table it or restructure the conversation. And I was intending to give, with input, direction. By all means, motion fails, let's continue.
Okay, so, well, I think there has been a first, so I have to hear if there's a second to table it. Hearing none, okay. Then we will proceed with the item number 11, the amendment. Okay. If we can have a report, please. Okay.
As originally drafted, the city charter required the board to take into account increases in local taxes and utility costs when deciding what each year's general adjustment, or GA, would be. Some of those costs, particularly increased utility costs, were included as a factor in establishing each year's GA percentage. Others were accounted for by regulations that the board enacted, allowing landlords to simply tack onto a unit's monthly rent a pro rata portion of specified costs. For example, in the early 1990s, the board enacted Regulation 3105, allowing landlords to include in a unit's rent a pro rata portion of school and college bonds appearing on a property tax bill. At some point, the board failed to comply with the charter by either of these methods with respect to local taxes and was sued. Excuse me, I'm losing my voice here, I'm sorry. The board settled that lawsuit by agreeing to account for increases in local taxes and bonds going forward, unless the charter provision requiring it to do so was amended by the voters. That charter provision was amended by the voters in 2012. As a result of that amendment, the requirement, and arguably the authority, for the board to allow for a tax and utility pass-through was eliminated. Regulations predating that elimination remain in place. One of those, Board Regulations 3105, allows the pass-through of the portion of voted indebtedness for school and college bonds appearing on an owner's tax bill, which item is based on an assessment of the owner's property. Because a property is reassessed upon sale, that item on the owner's tax bill may go up, sometimes dramatically, and if it does, the amount that Regulation 3105 allows the owner to pass through to the tenants as a surcharge of rents may also rise dramatically. The board has now directed staff to propose regulatory amendments to limit the degree to which this surcharge may cause rents to increase upon a property's sale and reassessment. Staff has proposed 4 possible approaches. The first is a simple repeal of the regulation allowing this surcharge. The second is imposing a dollar amount cap on the surcharge. Possible bases for such a cap could be 1, the median surcharge under Regulation 3105 for all controlled units at the time of the 2012 change in the city charter, and that would be $9.96 per month. This again applies only to the voted indebtedness surcharges that fluctuate with the property's reassessment. 2, the average pre-sale surcharge under the regulation for all controlled units that were actually sold and reassessed in 2012, which would be $12.61. 3, the average post-sale surcharge under the regulation for all controlled units that were actually sold and reassessed in 2012, which would be $30.02. Or the average post-sale surcharge under the regulation for all controlled units that were actually sold and reassessed this year, which would be $43.40. The third possible approach is to allow owners to pass through only half of the pro rata portion of the voted indebtedness portion of the owner's tax bill. The fourth possible approach is to clarify that only voted indebtedness approved by the voters before the 2012 charter amendment is subject to Regulation 3105, but otherwise do nothing, allowing the surcharges to end as bonds on which they were based are retired. The board could also, of course, pursue some combination of those approaches or craft an entirely different approach. As the staff report also notes, regulations are ordinarily effective immediately upon their publication unless a different effective date is specified. So that's something that the board may want to consider as well. Thank you.
Okay, thank you very much. I do have several requests to speak. Why don't we take the request to speak first, and then we'll have discussion from the commissioners. So the first person on the queue to speak is Bill Davids, and after Bill Davids is Michael Millman. If you can kind of be in queue there? Okay.
And yes, I just wanted to say, although you're hearing announcements about the library closing, we actually have until almost close to 10 o'clock, so we can use this room until that time.
Thank you very much. Mr. Davids, whenever you're ready, okay. And you have to speak, the red button underneath the
Thank you. Bill Davids, San Vicente Boulevard. I have spoken before the Rent Control Board 6 times now concerning the issue about the surcharges. In my particular case, as I indicated in public comment, on an annual basis back in 2014, my surcharges added up on an annual basis to $170. This current year, the surcharges now add up to practically $500, the surcharges that are under consideration right now. I have read the staff report twice, and my inclination when I was talking originally in public comment was simply to request a cap on the surcharges. I didn't realize that there was an option to completely repeal the surcharge pass-through to tenants. There's an indication in the report that there is no legal reservation about doing that, but there is a political reservation about doing that. Now, my being in Santa Monica for 27 years as a resident, I believe the political will of the City Council and presumably the Rent Control Board is that you want to maintain the stability of the neighborhoods, you want to maintain and protect the demographic diversity of the neighborhoods. You also want to protect the affordability of apartments, and you also want the older population to, quote unquote, age in place. These surcharges are acting as a detriment. They are acting actually as a catalyst for displacement of tenants. I was aware last year when I spoke, I indicated I knew a woman in a much smaller apartment building. I'm in a 90-unit apartment building, so proportionally, I'm obviously paying a much lower surcharge than a person living in a smaller apartment building that was sold. The woman that I knew superficially in the neighborhood told me that she was paying roughly $60 in surcharges when her building was sold, and I believe her building was either a 12 or 14 unit building. She wound up paying $95 per month in surcharges. That's almost $1,200 a year. This is financially toxic to most residents. When we get our rent increases, I now refer to it as the September shock, because basically we know in advance what the increases are going to be on the MARs, on the MARs, but we are not prepared for the increases that come through as surcharges for the school bonds and the college bonds. We are not property tax assessors. We are not real estate appraisers. We are not braced for this financially. Many of us cannot absorb this, and it's going to be an impetus for the displacement of tenants. We have been living in a superheated speculative market now for a number of years. We have multinational banks coming in, buying up property. We have real estate investment groups coming in, buying up property. We have very well-heeled investors coming in, buying up property. On a speculative level, the cost of property is skyrocketing, and tenants should not be held liable for the skyrocketing of valuations in Santa Monica. I noticed that there was a suggestion that San Francisco has a 50-50 share, a 50-50 split between tenants and landlords. However, that does not really quash the possibility of property valuation. Buildings are going to be bought and sold. I was reading in the New York Times that there are going to be humongous tax benefits to people who have apartment buildings. I'm not a tax accountant, but I think between the appreciation of property values in Santa Monica and the tax benefits that property
you.
owners will have.
Thank you, Mr. Davids. Just so everyone knows, there is a long list, and we are kind of pressing the time. So if we can be real vigilant about sticking with our time limits. Okay, there's a clarification by
Mr.
Commissioner
Davids.
Foster.
And thank you for coming again.
Sure.
You had mentioned the San Francisco reference. So just as a point of clarification, could staff please clarify for the speaker that it's not a 50-50 split of past obligations of any kind, but rather ballot language in any new ones so that voters, tenants, and landlords alike would be aware of what they potentially were entering into,
I see.
just so that the speaker is clear.
Yes, that's right.
Thank you.
Thank you, Mr. Davids. Okay, we have Michael Millman, and right after him, Carol Abreu. And Mr. Millman has requested 5 minutes. Oh, okay. And after Carol Abreu, we have Michelle, is it Huggis, I believe? Okay. So then Michelle Huggis after Mr. Millman, unless Ms. Abreu shows up. Whenever you're ready. So it's, yeah. Speak right into the mic.
Michael Millman, happy holidays. Short and brief, nothing to say about Metadaga. You know, minding my own business outside of my cousin, Matt Miller, brings me a circular that he got from our brothers and sisters called Santa Monica. This is how we got here. Our brothers and sisters at Spur gave a huge
you're gonna get is what Mr. David said. They're gonna sell out. And the person that buys it will be, you're right, the Chinese bank, or the Korean bank, or the Parisian bank. And then what we're gonna have is wholesale displacement because the numbers will go up and they'll Ellis the building and we're gonna start losing. Right? So, I appreciate putting it on the agenda. But we always need to set our compass and go back to the issue that's most important, which is preserving housing. You keep jamming these landlords. They are gonna pull that ripcord called Ellis. And you can spend $80,000 on a report or $38,000 on a report, but in the end, it's obvious to everyone on the dais, they Ellis when the units are so low under the market and when they're jammed every single year with a new kind of regulation where they feel put upon. Thank you.
Thank you, Mr. Millman. Okay, Carol Abreu. Not here. Okay, moving on then, we have Michelle Huggis, or
Maybe she
Hughes,
was-
perhaps? Not here, okay. We have Nanny Renell, Orenell, excuse me. And then behind her, we have Mary Stewart. Okay, so the first person we have, Nanny, I'm sorry, is it Grinnell or Ornell? She's from, no, she's from the staff in the back, the booth.
Oh, too bad. Ready to confront her.
Good evening.
If you could state your name for the record, please.
Yes, my name is Nani Grinnell. I live on Ocean Avenue. I've lived in Santa Monica for 5 years. And I spoke, I believe, in October regarding the pass-throughs, the tax surcharge pass-throughs. And I'm kind of a newcomer to this because this is the first time I've gotten the tax pass-through, the surcharge pass-through on my increase. And my increase is $121.83 a month. And that comes to $1,461.96 a year. And that's not including my rent increase. And it's crazy. But what I want to know is that how many people are experiencing this? I mean, are there thousands? Are there thousands of us? Or are there just hundreds of us? And some people are getting increases of $20, and I'm getting an increase of, $122. It's crazy. And we say that we're putting the new landlords, in a spot. We're not putting the new landlords in a spot. They're taking apartments that were $1,000 or $1,500, and now they're on the market for $8,600 a month. So we're not putting the landlords in any kind of jeopardy. They knew what they were doing. They knew when they paid that amount of money for our building that that's what they were going to do. They have right now. They have no in my building. They have no intention of Ellising it. They're just pushing people out one at a time and raising the rent to like outrageous amounts of money. And in the meantime, there's some people in my building who've been there for 30 plus years. So when this rent surcharge came through this past 2 months ago, they kind of were not terrified by it because their rents are low. Well, my rent is based on the fair market value of 5 years ago. So my rent is getting totally
outrageous. So, all I'm saying is that I'm so glad and I appreciate you jumping on this and coming up with a solution. But, you know, also on your website it says, well, we can't, if we come up with a solution, maybe we can't do it till next September because it would be complicated. Well, any amount before that or any time before that would be, we would be so grateful because it's money that's gone. I mean, wait till next September and it's another $1,400 for me gone. And, you know, I have no children in the school district because I'm a senior citizen and I'm a single senior widow with, you know, not a lot of money. So that's all. Thank you so much for getting on this. I appreciate it.
Thank you very much. There is one question from Commissioner Trosas.
Yeah, what's your address if you don't want to tell us publicly, maybe you can.
It's 1025 Ocean. And the last time I was here in October, I made copies for all of you with the tax bill.
Right.
Everything that, you know, goes along with it.
Can you remind me, had the building turned over in the last year or was that?
Yes.
Yeah. Okay. All right.
So this is the first time.
Yeah. Okay. Thanks.
And believe me, it was shocking.
Yeah. Okay.
So thank you so much. I'm very grateful for your attention to this.
Thank you.
Thank you very much. Is Mary Stewart out here? Okay.
Hello, Mary Stewart. Thank you for listening to me. I heard about the pass-throughs, the fact that they might be...
I'm sorry, if you could speak closer to the mic.
Is that better? Okay.
Yeah.
Hi, my name is Mary Stewart, and thank you for listening. I heard about the possible elimination of the pass-throughs a couple of weeks ago, and I felt like very important that I needed to speak about it. You know, I have twins, 19-year-old. Last year they were voting for the first time, and you should have seen them super excited, fired up. Oh, this looks good, this looks good, this looks good. And I'm like, you guys, you realize you have to pay for this, whether it's increased, you know, gas tax or sales tax, things like that. And their whole faces went like, oh, there's a responsibility. And, you know, basically in a nutshell, if the majority of the city, after careful consideration, votes on a bond, it's unfair now to reverse our current law and for a small minority to pay the debts voted on by a majority of the population. And that's how I feel. It's not fair that you're going to ask a small minority of people to pay for things. People are going to take advantage of it. The rule's going to be like, oh, let's vote on this, let's vote on that. You know, the landlords are going to pay for everything, the homeowners, the condo owners, and that's not fair. I'm born and raised in this town. So thank you for listening.
Thank you very much. There was a late chit that was just brought to me.
Move to accept for 2 minutes.
Okay. It's the first and a second to accept for 2 minutes. All in favor?
Yeah.
Okay. Mr. Surin Yadalia, 2 minutes when you're ready. Take your time.
Test. Thank you. Thank you for taking the time. Firstly, I appreciate it. I just felt, as an owner, I should just say a little something. There was some really accurate information given along the lines of that we want our children to be better. Firstly, that always comes as a priority. In the school system, I'm a product of it, and thank goodness Santa Monica has a great school system. Above all, that's great. And I think it is fair in the aggregate that we spread the burden across everybody that benefits from it, from oldest to the youngest. They all benefit from a great school system because these are the future Santa Monicans. They're going to raise their families here and hopefully just have a great life. And there was a point made, which is also very true, is that by not giving the pass-through, we are affecting the larger corporations, real estate trusts that are huge. They will be affected, but not as much as a smaller people. We're the smaller landlords with a few couple of units. We're taking the burden on more than anyone else by percentage. whereas a larger corporation can absorb that quite easily. Well, not easily, and not happily, but they can absorb it and continue doing business. For us, it's more of a burden than usual. And I'd like you to consider that. Part of that is just being fair across the board to all of our good citizens of Santa Monica. So thank you for the extra time. Thank you, commissioners, for listening. And have a good evening. Thank you.
Thank you very much. That concludes the request to speak. So I will close public comment. Now open for discussion. Commissioner Phyllis, excuse me, you're first on the list.
Thank you, Chair Duran. So I want to thank all the members of the public who came out tonight. I've also heard from members of the public prior to this meeting. And I want to make a couple points about values that motivated my interest with this item, and maybe address some concerns that folks here have in this audience. The first is tenants are potentially losing their homes because the limitations on the general adjustment that we've implemented are being essentially negated by landlords by not landlords, but turning over property values. So this isn't a situation where you're having a long-time mom and pop landlord hold on to a property and then you pass a bond and you're seeing a $2 or a $5 increase. What happens is the property turns over, it sells for 5-10 times what the landlord originally paid for it, and because bonds are assessed on the property value, you have tenants who are seeing hundreds of dollars increases in the surcharges, right? So that is the problem. And when I think a tenant signs on to a bond measure, which we've heard, I mean, I heard people who supported the bond measure say, on average, this is not going to be more than a $5 increase per month. This is not going to be more than a $6 increase per month. Tenants aren't expecting these properties to turn over. The problem isn't necessarily the additional implementation of bond measures. The problem is when these properties turn over, the value has so grown that when you pass through the new taxes or the new bonds, it is not just sticker shock, it is a matter of keeping their homes in some cases. So that's the problem that they're facing. Now, the other problem is, well, why are people turning over their buildings? And how do we want to protect people and not, for lack of a better term, screw landlords who have relied upon these pass-throughs right now? Because you have been expecting, I've heard from the landlord community, you have expected you will be able to pass through these bonds. That's how especially the mom and pop landlords, that's how you're making your ends meet. And that is something that I am very, very sensitive to, because those are particularly the landlords that I think are very close with their tenants, who have there's a personal relationship there. And I am particularly sensitive to that. And then there are the people who are worried about, is this going to make it more difficult to protect our schools, to support our college, which is a really important part of our town. Also a legitimate concern. We have to make sure that our schools are well funded, that our college is well funded, because that's also part of what makes Santa Monica so great. I think what we're realizing is the current system isn't working because it is hurting tenants in a way that is kind of unprecedented in terms of the speculation that we're seeing. And the new system that we've implemented, which was Measure GA plus these surcharges, is relatively new. GA passed in 2012. So, we're realizing now there's a problem, we have to fix it. What can we do to fix it? We've seen a couple items in the staff report. One thing that I want to be extremely clear on from the outset is I don't want anything that we do to jeopardize the funding that we have for schools and colleges in our community. And I think we have to be very conscious of that moving forward. That said, I think we really do have to think about how we are allocating responsibility so it doesn't compel landlords to sell their buildings or force tenants who can't afford a hundreds of dollar increase when they're expecting an $8 increase out of their building. I want to give a couple proposals that I think may also come closer to striking a balance down the line, and that I would like to see considered in a future staff report, because I think, well, this is a great start. You know, this is something we have to be really careful about. I know members of the public have asked for, you know, additional meetings so that they can further participate, and that's also something that I'm sensitive to. So one idea that I had thought about was potentially implementing some sort of sunset provision. And this is essentially how it would work, that landlords that are currently that own their building are protected in terms of their existing pass-throughs. So we're not taking a pass-through away from anyone. It just means that when the building turns over, after this regulation is implemented, the new owner cannot pass anything through, and therefore has to implement a calculation on what the additional amount of property tax will be into the new base rents that it's setting. I think that helps protect existing landlords who are relying upon these pass-throughs, but also gives notice to new owners, okay, this is a policy that we're no longer going to implement. That's something that I would like to see worked up in a future staff report, because I am very concerned about potentially taking away something that landlords are relying on now. The other item that I would like to see worked up is some sort of hardship exception that addresses the situation that we've heard from Mr. Davids, and I'm now blanking on the woman, Miss Brunel's situation, where we're talking about hundreds of dollars increase. And that would be in a situation with existing landlords. And in that situation, I would want there to be some sort of test for hardship so that the tenant could apply for relief. And it's not unlike the demonstration that we require of tenants for, I think, relief in terms of passing through the reg fee, right? Okay, so this is not unprecedented. This is something that we've done in terms of other pass-throughs, okay? And I think this type of test, in thinking about the two elements that I would want to be considered, first would be, you know, is this amount objectively a significant increase? So over the last 3 years, has it been an increase in more than 15% of the tenant's rent? Tenants paying $600 a month, you're seeing a $150 increase. That's the type of thing that should be threshold one. You're seeing a very significant amount of increase, okay? And then step number 2 is, does that increase actually burden the tenant, okay? And in that situation, I'm not sure how we determine a tenant is eligible for relief from the reg fee pass-through, but.
The eligibility for a waiver of the registration fee is based upon somebody being very low income and either senior or disabled. So
Okay.
it's not everybody. Whereas one of the pass-throughs based upon the tax assessments, the Clean Beaches and Ocean Parcel Tax, when the council adopted that, they provided a waiver for all low-income people.
Right, but we can also, when we're deciding what we want to pass through, can also implement some sort of a waiver.
We can look at that possibility, yes.
Okay, and that's something, you know, like, there are 2 eligibility criteria. One would be the objective amount of the increase, and the other would be, is this a hardship for the tenant? And one way that we could calculate, is this a hardship, is the same way that we calculate eligibility for the waiver of the reg fee pass-through. Those are basically the 2 kind of components that I would be thinking about. But we need to do something. I mean, like, we've now heard about this for over a year, that people are facing these hundreds of dollars increases. And, I'm sensitive to the feelings of my fellow commissioners that this is not something that we want to do with haste, and this is something that we need to do, you know, carefully. And I know it matters to my fellow commissioners. And I would like to see us really work to come together with a solution, hopefully, you know, early in the new year that can address this, because, you know, I'm worried about people losing their homes, and every tenant in Santa Monica should be concerned that if their building turns over and sells for a significantly higher amount, you will see a massive increase in the surcharges. And you could be talking hundreds of dollars. So every tenant should care about this issue.
Okay, thank you, Commissioner Phyllis. Commissioner?
May I ask a question?
Oh, sure, of course.
Oops. So when you talk when you're suggesting to look at whether it's a hardship for the tenant, are you thinking that that would apply to low-income people or limited to low or very low-income people?
I think I'm willing to hear what staff would suggest for determining is this a hardship. So low income, disabled, senior, the same types of criteria that we look to in terms of waiver from the reg fee. But I would want there to be two criteria. One is an objective, like a massive increase in terms of the percentage of rent, and then it would need to be a two-step, you meet both.
Okay, thank you.
Okay, Commissioner Foster.
Thank you. Like all of my fellow commissioners and like many tenants and landlords in this community, I too have been looking at this for a very long time, and it's been a matter, as a matter of fact, I have a friend in Mr. David's building, and so this came to my attention when the building indeed turned over 2 years ago. And I've been studying it ever since. And it's not a simple issue, and I've spent countless hours consulting with staff and with civic leaders and stakeholders on all sides in my own time, and not in a public hearing or meeting of any kind, but in gathering information for myself. And a few things strike me. First and foremost is transparency. I feel that there has been, and the staff report illustrates it very clearly, there's been some ambiguity and some lack of specific direction in how pass-throughs have been handled in the past. They were very clearly handled by hearings of the Rent Control Board after the 1990 and I believe 1992 or 3 measure. However, after that, and who knows why? I mean, just staffing changes, and there were no new hearings where the public or a board got to debate between landlords, tenants, and stakeholders in the schools and the parks and the beaches what, if anything, should be shared or passed through or in total or not at all. So for years, those things were just sort of muddled. Who's paying for it? Not quite sure. Until the lawsuit in 2011, which is explained in the staff report. And after that, it was said that these things are going to be passed all the way through, if and until language in the charter changes. I don't believe that every tenant in Santa Monica is aware that they're paying 100% of all of these taxes, and that the landlord, in fact, of those particular taxes are not paying any. So one of my issues has not ever been that there shouldn't be any sharing or any pass-through at all, but that a sharing of some sort, and this is what I want staff to show us much deeper and further examples of, a sharing of good schools, a sharing of clean beaches, because the landlords are correct in asserting that if they perhaps live in Minnesota and own a building here, that there are people living in their units who are voting on things, if they are in fact registered voters, that hey, and the old guy will pay for it. Well, that's actually not the way it's been working. Things that the voters have enacted, they are paying 100% divided by the number of units. So just in the spirit of transparency, I openly supported Measure V. I have supported public school and voted yes on bond measures for the last 10 years that I've lived in Santa Monica. And I have no problem paying for those myself and offering things forward. However, I think in the spirit of a public discussion of it, that the fact that tenants are currently paying 100% of all of those is relevant. The other thing is, when I brought forward the information sheet a few months ago, part of one of the arguments I made at that time was that when you're entering, when a private person and a private landlord are entering into a contract together, that they should both be aware of all aspects of the contract. And the reason I took input and we all built a beautiful information sheet was that A lot of people didn't know what they were entering into, and that sheet, I hope, at least for new tenancies, would help better inform some landlords who might not be aware of all the current laws and regulations, and some tenants who have no idea what rent control is. In that same spirit, if you're entering into a new lease, or any lease during the rent control period in the city of 37 years, I think people entered it with an understanding, especially if it was their first time in Santa Monica, that there was a MAR, there was a maximum allowable rent of some kind. And the idea of these pass-throughs would seem to sort of fly in the face of the word maximum. The registration fee works for me because it's an equal sharing of an independent board that does not rely on taxpayer funds in any way, shape, or form, fully funded by the property owners and the tenants in exact half. That makes sense to me. So there are deep issues on both sides. There's no question in my mind that landlords have come to expect that post-Costa-Hawkins vacancy decontrolled rents that they set in the year 2000 or the year 2005 or the year 2007, they had, especially after 2011, they had a reasonable expectation that they were going to set the rent at X and then they were going to pass through some surcharges. I do have a little bit of problem with that in philosophy, only because by having a vacancy decontrolled rent that they can set, they were supposed to be able, by virtue of Costa-Hawkins, to take their expected, in other words, past bond measures that were already passed and already being implemented. They know what those dollar amounts are. And if they could recoup that in a new rent that they're setting, they get to do that. Then to, the next July 1st, be able to say, and $68 more, they already kind of knew that that was baked into new rents they were setting. So even saying that, the result of the lawsuit in 2011 was what it was, and I don't disagree with it. However, it did say if and until the charter language changes. And for me, that change took place by the voters in November of 2012. The charter language changed to only stipulate what the new general adjustment would be calculated by and not by other factors. So here's what I would like to have staff take a look at further, and if there's agreement with my fellow board members, I know there'll be a lot more commentary, but I just want to get this out while it's my turn. I would like to further examine the other tax pass-throughs, the direct assessments that are not based on reassessed value but on fixed value, because they should probably be examined by all of us and by the public in total. I would also like you to present to us information on how this affects tenants in TORCA units and owners of TORCA units. And for the public, those are apartment buildings that converted into condominiums. Because some of the taxes are parcel-based, tenants who signed a lease for $1,000 or $10,000 suddenly found themselves paying the entirety of a parcel tax, just like any other homeowner in Santa Monica. So that's, again, something that when you're entering a contract, usually you know all the stipulations. Those tenants did not know that 12 or 14 or 16 months later they'd be getting an increase for something they had no idea was part of being a tenant. So I'd like to examine TORCA, the effect on TORCA units. I'd also like to examine arguments for and against or neutral on pre-Costa-Hawkins versus post-Costa-Hawkins rents. And the reason is for what I have already stated. I could see a scenario in which after this board enacts some sort of regulation regarding these pass-throughs, that there be an immediate stop placed on passing through anything to newly set rents after that date, because landlords would be on full notice that, in other words, if they were going to charge $3,000 for a newly vacant unit and they know that they're no longer going to be passing through something, if that's the case, that they'd say, I'm going to charge $3,035 because now I know I'm not going to be able to tack that on next year, since I already know what the amount is. And I appreciated the part of the staff report that stated that any future ballot measures could clearly, perhaps, like San Francisco does, propose in the ballot language, after presumably some testing and polling of the popularity of such a notion, that it be clearly illustrated that property owners and tenants, in the case of tenants, would be expected to share in it, and that an approximate amount per thousand or per month might look like A, B, or C. Much like the great staff that wrote Measure V was willing to publicly talk about that at every whistle stop. I heard them because I was campaigning alongside them, and I heard all those presentations. So in San Francisco, you can only split it 50-50 and pass it through if it was expressly stated and voted on by the voters in that. And to that point, I just want to remind, while the tenants are the ones that it would seem directly benefit from schools or beaches, it's also the owners that benefit from a city that improves its infrastructure and a city that improves its schools, to the point that I have neighbors who are only living there and paying exorbitant rents that are in excess of 50% of their income so that their children can go to those schools. In other words, the value of the units themselves go up by virtue of the great schools without any improvements to the unit in some cases. Further and lastly, a couple things to add to staff direction. I would like to know what the city figures are on the median of all current pass-throughs. The thing in the staff report I did not like about the potential dollar amounts of any potential cap after a sharing of some kind was that they were predicated upon an exact 70 properties that turned over during a certain ebb and flow in the real estate market. So I would actually like to see a historic average in medians and averages in pass-throughs and property values, and similar to the chart you presented, but in a broader sense, because limiting it to one swing in the real estate market doesn't seem to be truly representative of what it might look like. The other would be to study the legality of using the 2012 charter language as the beginning of a timeline. In other words, how would we treat measures ES, which was passed in 2012, and measure V, which was passed in 2016? So I'd like to look at in detail at how those two measures, different proposals for how staff would propose handling the administration and or implementation and or subtraction, whatever the case may be, of measures ES and measures V. And also the legality, if any, of any rents that are set after any regulations we would pass, limiting the pass-throughs on those units at all. And also what a cap, what any sort of an equitable sounding cap would look like, what formula, in other words, what formula would staff recommend using, and I'd like to see hopefully more than one possibility for a formula for if perhaps there were a splitting and a cap, the cap intending to protect from speculative real estate or large increases for overturned buildings that turn over, what that might look like. That concludes my remarks. I just reiterate to the public that this has been top of mind for a long time, and we're all glad it's coming to the fore for a discussion. And we welcome stakeholders, property owners, schools, beaches, advocates, definitely property owners, and renters, groups, all putting their input on this. And we don't want it to drag out. We don't. But we do want it to be thorough and really fair and equitable to all parties involved. Thank you.
Thank you, Commissioner Foster. Commissioner Flora.
Yes, thank you, Mr. Chair. Commissioner Phillips, first of all, I just want to thank you not only for agendizing the issue, but for saying what you did about acknowledging that all of your fellow commissioners really care about this issue. I did bristle a great deal at a couple of you using the term dragging our feet. I just want to get this out of the way now. It does not need to be responded to, but I will say the first meeting I attended on this board was 7 years ago this month. I was elected the month before that in November of 2010. Not to sound overly prideful, but if you've been on this board that long and seen and done as much as I have, you can tell me I'm dragging my feet. If not, I appreciate you recognizing that some of us recognize that this has been an issue for a long time, but the fact of the matter is we haven't been talking about this for months. We've been talking about the need to talk about this for months. Now we're finally for the first time talking about it. So some of us saying, gosh, maybe we need more than one meeting, and I think it's more than clear now, and even from yourself, who've given some direction that would need to go beyond tonight, would acknowledge, we're going to need more than just this meeting. So some of us starting out saying, hey, can we make sure we talk about this thoroughly, I don't think amounts to dragging our feet, and I appreciate what you said, because we do all care about this a great deal. And I can't add much more to that impressive menu of homework, worthy homework that Commissioner Foster has given the staff, except to add, to back her up in saying thank you for stating what you did about the fact that property values and landlords benefit as well. You don't find cities with good schools that aren't also good cities, that also don't have good property values. So you're not going to convince me that if you're a landlord, you don't benefit from good schools that become good cities that give you good property values. That said, I do appreciate what Ms. Stewart said. We should all have some skin in the game. Absolutely. I am childless, and I've never not voted in favor of taxing myself as a homeowner, be it parcel or bond, for schools measures. One is because I really care about kids. I know a lot of people that have kids, just because I don't have any of my own, and I care about living in a community with great schools. So we should all have some skin in the game, but I do really appreciate the staff report, and I do hope that you, as a staff, can take these next few weeks, maybe work with Commissioner Torosis on a Saturday. I don't know what it's going to take. I'd be happy to be there. Bring some snacks. But in all seriousness, to consider some of the things that both Commissioner Phillips, Commissioner Foster, and I'm sure my other commissioners are going to bring up. The only thing I would add to that menu for consideration, if it wasn't already stated, you may have hinted at it, was that perhaps there also needs to be an option, E or F or what have you, where not everybody is treated the same, where perhaps there are different tiers. I know we like to keep things simple. We don't want to overly complicate paperwork or whatever, but at the same time, I don't necessarily think taxes need to be paid on a postcard to have a fair tax system. So maybe we don't need to be so simple that we're also not just in how we factor out some of these surcharges. So perhaps there is a 2 or 3 tiered system. Perhaps we don't treat everybody the same because we say something like surcharges cannot be more than X% of your rent. So that does mean something different for every renter, but it's also maybe a simple way of putting it. That could be an option E, for example. So I do think there's a little more homework to do. I would, for one, really like to hear from more of the public. And again, I'm glad we did talk about this tonight. Yes, I am glad we started the discussion. We've needed to, but I do hope we complete it and come to a conclusion. People are waiting. Commissioner Torosis is absolutely right. And this is affecting people's lives now, but let's do this right and make sure we have another good public hearing where I hope we can hear from more of the public. This is our 3rd meeting location in as many months. It is December. It doesn't seem to have hurt attendance tonight, but let's give some other people a chance to weigh in. And I invite people to write us, email us, renters, tenants, landlords alike. Please come to the meeting. Please write us on this issue and tell us about your experience. Thank you.
Thank you, Commissioner Flora. Commissioner Torosis.
Thanks for your comments. And I just want to echo what you said, Commissioner Flora. I